Okay, so we'll start with the director's obligations. Now, there are a number of laws which prevail, and look, one of the conditions in these NDIS laws and regulations, as is with any administration law aspect, even education and care services law, for example, if it's a family day care, um, one of the conditions that applies to all registered provider is that they oblige with state and territories and Commonwealth laws. So it's not just the NDIS Act that applies. There are a number of other laws. For example, in this case, there's Fair Work Australia Act, or it's called Fair Work Act. You have the award and ATO rulings. Obviously, anything that is legislative instrument. You might have things like even privacy law, for example, or Privacy Act that applies. So ultimately, it's not just the NDIS Act and its ancillary regulations that will apply, but a number of regime regulations where state and Commonwealth laws are concerned, they all will apply. So you've got to basically make sure that you don't breach any of those laws. Look, laws are quite interesting. Most of them, most of these laws, if you look at it, they will be aligned with common sense. So it is very rare that you'll have a law that does not make sense. I spoke about that. I mean, from time to time, you have laws which are sometimes deemed unreasonable, but then look, again, in those cases, you will have a court that will need to interpret it and say, look, this law is inconsistent with, for example, human rights or whatever. But normally you will need to abide by these laws. And if you're not clear about laws, what laws apply and what rules apply, NDIS, for example, NDIS Commission has made a lot of simple, like pamphlets which have information about what to do and what not to do. So these are like translating the actual laws, which are sometimes hard to read, into simple English. So you can get all these brochures and information from NDIS websites. Yeah. So if you can go to the next screen. So the key point takeaway from there is that it's not just NDIS Act, but other laws. Now, we will be focusing on the director's duties, and also sometimes referred to as key personnel. Now, there are, when we say key person, what does that mean? So, you may have someone who has got a PTY limited company or proprietary limited company, which is a registered NDIS entity, also called provider. Now, in this case, the director of that company is responsible for the running of the company, day-to-day operations. So they are referred to as key personnel. But also, you might have supervisors or key supervisors, or sometimes people call them operations managers, general manager. You can name whatever. So those people can be included as key personnel. So it's not necessarily just the directors under the Corporations Act who are there's someone who is seeking entry. Thank you. They're not. It's not necessarily just the directors of the company and the Corporations Act. They are also people who are responsible for day-to-day operations. In terms of the shareholders, another thing that we'll discuss in maybe if you want to go to the next screen, because I think some of these issues are going to come one by one. So yeah, Jessica, if you want to move on to the next screen. So basically, some of the things that are relevant are obviously your suitability requirement. That is the key issue that NDIS often raises, right? And NDIS Commission, look, from time to time, they're reviewing their registrations of providers as well. I've had many cases where, for example, people had NDIS registrations, but previously when they had a family daycare or they had an RTO or another government associated entity, there was some findings of non-compliance against them. So that was in the past, 4 years, 5 years ago. And now they have been running the NDIS for some time. And all of a sudden, they get this notice from NDIS Commission. It says, hey, you're not a fit and proper person. You're not a suitable person to operate an NDIS service. So what happens then, as a requirement, a natural justice requirement, they will give you an opportunity to then address that issue or their objections or allegations, and then you provide submissions. So we have got a number of issues where we have provided submissions, and we have been able to safeguard the interests of the registered providers where they did not interfere with their registrations and they let them go. Again, it just depends on case by case basis. Everyone's case is different. Where there is no clear allegation of dishonesty, for example, especially related to public money, in that case, normally it is not a very simple sort of I suppose, a simple consequence or a sanction that NDIS Commission can apply to you. There are obviously rights that you have. And one of the rights is that you are deemed as a person who is suitable unless proven otherwise. So it's not that the starting position has to be that you are someone who is not suitable. So at law, that is basically a position that you are a suitable person unless there is some adverse information about you. What are the issues that can affect you? Things like bankruptcy, insolvency, things like non-disclosure. If you had any issue in the past, but you did not disclose as part of your NDIS application, things like criminal, obviously, conduct, if you have been found guilty of offenses in the past. It could be generally, obviously, one other question is if you owe money to someone in a private capacity, are you going to be deemed as someone who's not suitable? So a quick answer to that is no, unless, of course, there's court proceedings, there is some judgment against your name, or there are, bankruptcy proceedings and that sort of thing. Or if you had a company previously, then whether there was any issues like insolvency and whatnot. So as long as you're clear from that, most of the time, and obviously the common sense things like you're of the sane mind, and you're able to make your decisions. You have the legal capacity to do those. So as long as you've got that, then you would meet the requirements under the suitability requirements under the NDIS Act. Now, there's Section 9 and Section 10. What's the difference? Look, one section deals with the key persona and their suitability. The other is about the company itself, or if it's a registered provider, which is a PTY limited company, then it will be company. As some of you might know, a company in its own right can be sued and sue. So it's like another different person altogether from you. So there are requirements that NDIS has to consider when issuing the registration, and during the registration as well, the NDIS has every right to apply Section 9, Section 10 suitability requirements and ask you to explain, why or what happened, or if there is any issues. And then, of course, you get the natural justice right to respond to those allegations with evidence if you have, or deny those. And as long as you've got good grounds for that, they will normally not interfere with your registration. Okay, so if you go to the next one. Yeah, so this is basically more the Corporations Act. And as I said to you in the first place, when you're running an NDIS business or any business under administration act sort of regime where you have public office dealings. For example, public office means government offices, right? Where you're getting payment from government. Centrelink, it could be Department of Education, as I said to you, it could be NDIA, a number of other grants and schemes and whatnot. When you're dealing with those, then there are some additional requirements. And one of the requirements that I started with was that you have to comply with state and Commonwealth laws. Now, Corporations Act is a Commonwealth law, right? This is basically applicable all across Australia. So Section 180, in very simple words, what it means is that the director, if you're a director of a company, then you've got to exercise due care and due diligence. You have to make sure that you are not negligent in your duties. One of the issues that come in NDIS sometimes is that, you may have two people who are in a PTY limited or proprietary limited company who are the directors, and they're also the shareholders. Now, as shareholders, being a shareholder is a different thing. So it's like you are owner of that company, but you do not run the day-to-day operations of that company. But when you become a director, it's a different story. So when you become a director, you run the day-to-day operations of the company. So you are legally liable. Some people say, well, what if I'm a sleeping director? What does it mean? These are all terms which are not really recognized at law, but they are referred to in legal fraternity as to indicate a person who is a director but is not actively involved in running of the business. So can that person be held responsible? The simple and short answer is yes. Even if you are sleeping director, you are still responsible and can be held liable. That goes for any duties under the NDIS Act, but also ATO rulings, and generally across things like superannuation guarantees and PAYG payments and all that sort of thing. So you will be responsible. Now, the rest is, I think, it's common sense, and you're not going to misuse a position. And then if there is recklessness or dishonesty, then you have certain matters can apply criminal consequences. What also, for example, insolvency, if you know that your company is not able to trade, it hasn't got enough money to pay its bills, but it continues with that, then that means that your company is insolvent. You should not trade. If you do that, it can be a criminal offense. Similarly, if you've been reckless, if you have done dishonesty, the corporate wheel, and that's again a very different. And so I'll try to reduce what I'm saying, because otherwise, on this one topic, I can talk about 1 hour. Corporate wheel and how it can be pierced and what pierces it. So I'll just keep it very limited. But just the key takeaway from this screen is that there are obligations on the director to act in the best interest of the company, to act with care and due diligence. And if they are found, if they're reckless or dishonest, then they can be criminal penalties. Next screen, please. Okay, so I've briefly touched on that. If you're insolvent and you incur debts, then there can be a problem, which basically means, in essence, the practical implication of that is that normally if you have a Pty limited company and you own a house under your personal name, for example, right, then they can't really come after your personal asset, which is under your name. But if you're insolvent and you're trading, then that corporate wheel, which is protecting you, can be pierced, and then they can come after your personal assets. Yeah. And of course, like I said, disqualification, there's some other things, civil penalties, compensation orders, criminal liability, that can all eventuate. But the real effect on the financial side of it, mostly is going to be that even if you own something under your personal name, they can have access to it. Yes, next screen. Yeah. All right. So this is, again, this is another issue that is quite interesting, if I may put it this way. Look, I've got a lot of people who ask me, well, can we do an independent contract agreement for people who are, providing services? For example, they are carers, disability carers, and they're going to the homes and look after. Can we do that as, independent contractors, subcontractors, as PAYG? So what needs to be understood is that the reason why there's a SHADS award is because those people under the award needed protection. And the government thought, well, we're going to provide protection to these people who are working in the NDIS and some other industries, some associated public service industries. And so to get around it and to cut corners, there's never going to be an answer. You can never get an answer from a lawyer to say, yes, it's okay, because it's not. The reality of the matter is, ultimately, the best way, if you have an arrangement with someone to go to someone's home and provide care, and that person is generating his income, around 80% of his income from you, and that person has got no option to go and work for someone else, you might call it independent contract, you might call it subcontract, but in reality, he may still be deemed as someone who's your employee. And they may be, and I say the word may because every case is different, what sort of contract you've got, how well protected it is, what sort of disclosures you have put in your employment contract, or if it's not employment contract and it's an independent contract arrangement, then what is actually written inside. The problem with that is a lot of people just go and they buy ready-made contracts from internet. They're not customized. So when they give this agreement or contract to the person who's going to be working, whether it's an employee, whether it's a contractor, subcontractor, or independent contractor, in either case, it's not going to cover them. And those provisions or clauses that are in the employment contract, when tested by Fair Work or tested by federal court, will not be adequate to protect the business from saying that it was not a PAYG arrangement. Why? Because neither the business understood what's in there, nor the employee understood what he's signing. And if you have a non-customized, off-the-shelf contract, that is a really big risk. So I would suggest all people to review their contracts. If they want to have an independent contract arrangement, yes, there are provisions for that, but then there are certain requirements that need to be met to differentiate the employment arrangement. Just saying that this is not an employment agreement does not protect you. So obviously, again, it depends on whether those people go to Fair Work Australia or try federal court. If they do, and the employment looks like a PAYG, it acts like a PAYG, it talks like a PAYG, then it is a PAYG. Okay. But so be very careful. It all depends on what you write between yourselves and how you structure that employment. I think that's pretty much it. I mean, there are some cases which I don't want to refer because, again, we'll go into very long detail discussing them. But the key takeaway is that be careful with how you put your contracts, review your employment contracts. If you have employment contracts with PAYG, if you have independent contracts, review them as well. Okay, so 80% income rule, I'll just briefly touch on that again. So this is where, look, there are, you're aware that there's super guarantees, for example, that you have to pay superannuation. Again, it depends on the type of contract, the structure of your employment or structure of the work that you have, how you have structured your work. What are the parties involved and everything else? Whether they have the right to go and work with second person, another NDIS provider. How many hours in a week do they work with you? Have they got a desk in your office? Have they got your tools of trade, or have they got their own computers and whatnot? So a number of have they got maintained their own insurances, or have you got professional indemnity or public liability insurance for them? So all of these factors they have to be taken into account. But 80% income from one client, basically what it means is that, look, if you're working for 80% of the time with one person, then likely you are responsible to pay the super and the taxation. Yeah. And look, one disclosure with that is in terms of calculating incomes and everything, you've got to speak to your accountant. I'm not a financial advisor or an accounting professional. I am a lawyer, and I can only give you legal advice. Thank you. Next screen. Yeah. And that's another big one now. So restraints and anti-poaching, what does that mean? Okay. So with the restraints, look, it is somewhat of a binding of someone who's working with you. And this is one of the biggest problems in NDIS industry, especially because, as you may be aware, if you're operating in the industry, you know that people have come in and they have, I've even got instances where people have actually kidnapped some participants, believe it or not, and taken them with them. And then we had to recover, we had to engage the police, we had to, engage sometime court proceedings, intervention orders, domestic violence orders, all that sort of thing. We had to go through to get the participant, again, we will get into long, lengthy discussions, but okay. So if you can mute your mic, that'd be good. I think there's someone who's got a mic unmuted. So friends, as I was saying to you, the important thing is in terms of restraint of trade and anti-poaching is, especially with NDIS, you know that people are on the front foot, right? There is obviously the participants have something called choice and control, which means that they can go and pick any NDIS provider they want. They cannot be bound by an agreement, in other words. Now, how this is misused is that some NDIS providers will be just, using tactics, coercion, some other, and these are all reports available in the media. I don't need to tell you. I think you're well aware of what is happening in the industry. So you want to make sure that people who you employ or people who you contract, even allied health professionals, right, nurses and all that sort of thing, you want to make sure that they are somehow bound legally, that they do not poach your clients. Yeah, it is one thing a participant says, well, I'm not getting good services here, I want to move to someone else. Yeah, that's fine, you can't do anything about it. But if that person has been contracted by you, let's say an allied health professional, and he or she is the one who then approaches your client, and then the participant after, or your client or participant after having those discussion with this allied health person comes to you and say, I want to change, then it's a different story, right? Because in the first instance, it's a choice and control. He wants to move, he wants to move. But when there's someone else involved who has done something wrong, who has coerced their mind, or who has influenced that person to move with them, very often, if you don't have a proper contract which has restraint of trade in it, or anti-poaching policy, if I can put it that way, then you cannot, the legal options become very limited. But if you have a very good contract with those people, where you have restraint of trade with them, where you have the anti-poaching policy, then you can sue them. A lot of time people will say, no, we don't want to sue. That's okay. But it is still a deterrence. Why? Because they can see that this is wrong. They're not supposed to do that. If they do that, that would be a breach of contract. And if someone breaches a contract, then obviously they're responsible. Another question gets asked quite often: if someone is your employee and they go and they set up their own NDIS, provider business, and they take your participant. So, and what if you don't? Okay, so if you have a contract which has clear anti-poaching in it, which has got restraint of trade, you will be very well protected. Even if you don't have a contract, can you still be protected? Yes, technically you can be. There's a common law duty, something called fiduciary obligation of an employee towards an employer. But again, it is not unlimited. In other words, if the person, for example, has left you, right, there may be some provisions which will apply. For example, confidentiality. They're not supposed to take the information of the participant with them or use it in a wrong way. But in terms of whether that person can poach away your participant after they finish working with you, not really. Sometimes you have to prove. But if you have a good contract which sort of enumerates these obligations of the employee towards you, post work and also during work, you're very well protected. So there will be a breach and there'll be a deterrence. Even if they go to their lawyer, all you have to do is do a legal letter, and their lawyer will tell them, well, you're going to be in deep trouble. You better get out of this mess. Yeah. Okay, next one. So there are a number of cases cited there, but we don't really need to go in detail. Like I said, we don't have much time, but individually, if you want to have a discussion, I'm more than happy to. And also on my, I've got a YouTube channel as well, where you can get this information. There's a number of videos addressing these matters in detail. They will be, not are. I'm just starting that now. So yeah, and Cheska can give you the link or share the link of YouTube if you want. It's just for educational purposes later. So governance risk, again, that's a breach of Section 180. We have discussed that, 180 to 184, directors' obligations or duties. Regulatory risk, that's Section 910, suitability matters. Shared award contraventions. It's come, well, Section 550 FWA liability obviously enlivens. But in this case, it is a shared award breach level or contravention level enliven that liability provision. Then you have, yes, the personal income misclassification, as we've discussed, the responsibility of taxation, paying PAYG tax, and also the superannuation guarantee or liabilities. Contractual risk, and these are unenforceable restraints, client staff losses. Again, as I said to you, if you have a contract that has restraint of trade in it and good anti-poaching clause, then, and that makes sense, and it's not something that is unreasonable. Be careful with that. Sometimes you would just ask, ChatGPT to write anti-poaching clause with you for you, and then what happens is, when tested by court, it is found unjust and unfair. So that will be set aside. Okay. So always get legal advice on that. Yep. Next. Okay. So conclusion, and I think we finished. Cheska, I thought we were going to take half an hour, but we are doing all right. So
Yeah.
we can do a quick question answer after this if someone has got any questions. So directors are accountable, right? As corporate officers, this is common sense. And key personnel as well, not just the people who are under Corporations Act nominated as directors or secretary, right? This for NDIS purposes. The suitability matters. I've discussed Section 9 and Section 10. Governance arrangement, I've discussed Section 180 to 184 of Corporations Act. Employment obligations, again, shares award, Fair Work Australia, and also you can add federal court to that. Some people could go straight to federal court as well rather than going through FWA. Again, depends on the circumstances. What's the difference between FWA and federal court, right? FWA or Fair Work Australia is a tribunal, and a tribunal gets its power or its power and its decision ability or judgment ability based on the law that's there, right? So it has to be a written law or legislation. So it cannot go outside of that. So it cannot decide what's fair and what's not, right? For example, a number of times you will have people who will say, well, the Fair Work is only for employees, but I have an independent contract with me with the ABN number. My contractor has an ABN number. So Fair Work Australia does not get the jurisdiction. Now, Fair Work Australia may be limited in that because, as I said to you, the tribunals and even ART, ART and also VCAT, for example, in Victoria, if you're in Victoria, these tribunals, they are limited by the written law. They can't go outside of that, as opposed to federal court, which has got something called inherent jurisdiction, or for thousands of years, the English law and everything else, they can make a decision based on law and equity. So they can also decide what's fair and what's not. So that they have a broader sort of jurisdiction, if you like. And therefore, the decisions that they make can have broader implications.